Child support modification and child support enforcement in the state of New York. What are the basics of these two topics? First of all, when it comes to child support modification, to get a downward modification is a very difficult thing to do, so I would never suggest that you do it without counsel. Many people go into court and they will try and litigate issues of child support, whether it be an increase or a decrease, without having counsel, and it's not a simple process. So make sure you have counsel, first of all. Second of all, to get a child support modification, you have to show a substantial, unanticipated change in circumstances. That has to be something that is unforeseen. I will tell you that generally speaking, if you are laid off and receiving unemployment, you will be able to get your child support modified. If you are injured and placed on workers' compensation and you're a W-2 wage earner, generally speaking, you're going to be able to have your child support modified to what you're receiving through workers' compensation. If you are self-employed, it becomes a much more difficult analysis, a much more difficult factual problem for your attorneys. Many times when people are self-employed, the courts encounter people who are playing games with reporting their income, and they come into court and pull their pockets inside out and pick the lint out of them and say, you know, I'm broke, and they can't make any money and they can't make their support payments. That is definitely a situation where you are going to need to have counsel, and you need to be able to establish it on a factual basis as to why you cannot make what you had made before. The other thing that I always counsel people when it comes to child support, when you have an order in place, if you know that there is going to be a change in your income, and you know that you're going to be earning less, whether it be a workers' comp situation, you're going on strike, you are going to be laid off, you should walk into the courthouse as soon as you know that that happens and file a petition to modify your child support in a downward manner. You should, you know, even if you don't hire counsel, get that petition filed and then go find an attorney, because your attorney can change that petition. They can modify it, they can amend it after you've already filed it. Why do I say that? Once arrears add up, once you've been unable to pay your child support obligations and they are adding up, if you have not filed a petition, the only way that you're ever going to get those arrears reduced is through agreement from the person who's receiving child support. Chances are, if you're divorced, it's going to be a little harder to get agreement from that person that you've been divorced from to get those arrears reduced. So the only way that you can place it in a situation where you have some control over it is if you've got that petition filed. So make sure that that petition to modify your child support, because there's going to be an interruption in your income, is filed as soon as possible. Don't wait. Get in there, get an attorney, get the petition filed in family court, act on it as soon as you can so that the arrears don't add up and it turns into a situation where you're going to end up with a judgment through the roof because you've been laid off or you're out of work on workers' compensation or something of that nature. When it comes to enforcement petitions, generally speaking, what we try to do when we're representing somebody and they've had arrears accrue is we try to put it into a situation where there's a repayment arrangement. I will tell you, this is a situation when you have a lot of arrears that have added up where people can, in fact, be incarcerated for it if they're found to have willfully violated an order. It's called contempt, and you can be placed in jail for child support arrears. The way you get around that is pay something. Always pay something. I don't care if you're collecting cans and you're paying $20 a week. Pay something if your income has been interrupted and you can't make ends meet. Throw $20 at the person who's supposed to receive child support from you on a regular basis so that we can at least make the argument that you're trying to do something to meet that obligation that you have. The courts are not going to care about every other obligation you have. Supporting your child is going to be paramount. That is the first thing that you need to pay, more so than even buying groceries for yourself. So make sure those things get paid. But generally speaking, what we're going to do is we're going to try to get a situation where we get a repayment arrangement put into place with something that is livable for you, keep you out of jail, keep you working, keep you paying. That is generally what the recipient of child support is going to want to have. So if you find yourself in a situation where you need to discuss your child support obligations, please feel free, pick up the phone, call us, send us an email. Let's talk about it. Let's see if we can work this problem out for you. Let's see if we can put you in a position where the circumstances are, you know, something that you can live with.